Да я с сумкой хожу, потому что
Це вже це з водафоном. Справа в тому, що перед Новим ріком я поміняла телефон і номер зберігла, але сім-картку не викупила. Я так розумію, це проблема вже. Зараз я перезавантажила телефон, бо мені потрібно приймати.
Доброго дня, вітаю всіх, хто прилучився до нас в Zoom. Хочу обговорити декілька тих.
Good morning. I'm happy to see everybody who joined us via Zoom. I will say few words on how we shall proceed today from the technical standpoints. In the first place, you need to switch off your micros. Second, you need to choose the channel. It's mandatory even if you speak both languages. So if you prefer to listen and intervene in English, please choose English language. In order to do so, please go to the bottom of your page, click on the globe, choose the English language and mute original audio. If you prefer Ukrainian language, then do the same for the Ukrainian language. Louisa Romanadze speaking. Good morning, dear colleagues. Thank you for joining this event on mediation. This event has become possible due to the joint support of donors and partners. It has been indeed a joint effort. All the partners are present here today. I'm grateful to the Pravo Justice Project, to the Fifth Court of Appeal located in Odessa, to the National School of Judges of Ukraine, and to our highly respected friends, the Association of Mediators of Georgia. I'm now giving floor to Marina Mishkina, judge speaker from the Fifth Court of Appeal. Dear colleagues, dear friends, it's a pleasure to be here. It's a pleasure to see all of you here, both offline and online. I will start by saying the words of gratitude to Louisa Romanadze, President of the Ukrainian Association of Mediators, and Dovida Svitkauskas, team leader of the Pravo Justice Project, as well as other partners, namely the National School of Judges of Ukraine, the Association of Mediators of Georgia, the Association of Advocates of Ukraine, and other partners and experts for having organized this event and for being ready to provide this platform for sharing experience and best practices. Our conference is unique because it will present the experience of international experts and national adults of mediation who have been piloting mediation projects in Ukrainian courts. It's indeed a very unique opportunity. I'm very grateful to all the participants again for having joined the event, for being involved. I wish us all Good luck, productive discussion, and fruitful sharing of experience so that we could really implement and boost this instrument of court-annexed mediation in Ukraine. Thank you, Marina. And now I'm giving floor to Vladimir Mazurok, Prorector of the National School of Judges of Ukraine. My sincerest greetings to all the participants, experts, mediators, judges, lawyers. The conference has been co-organized by the National School of Judges of Ukraine together with other partners and organizers. The event is being supported by the Pravo Justice Project, which is a European EU-funded project. On behalf of the National School of Judges, I wish to all the participants nice and fruitful cooperation. I cannot but say that the world practice is very much in favor of mediation as a tool for dispute resolution and settlement, both at the pre-trial stage and during the trial. On the 21st of May 2008, the EU adopted a directive which aimed at simplified access to alternative dispute resolution methods and stimulating of greater use of mediation and dispute settlement. In the preamble to the directive, the author says that the directive is intended to cover international mediation. However, nothing impedes these provisions to be applied to any mediation process. I'm very pleased to see that mediation and alternative dispute resolution become more and more popular as tools of dispute settlement. The National School of Judges has held a series of seminars across Ukraine, which were dedicated to mediation and to possible ways of cooperation between courts and mediators. That endeavor was supported by international partners. The seminars covered a legislative framework for mediation in Ukraine, including the existing legislative procedural provisions. The seminars were attended by judges and facilitated by judges, trainers, mediators, and national and international experts from Ukraine and abroad. The National School of Judges covers alternative dispute resolution in other courses facilitated and provided in the school. The National School of Judges makes all efforts in order to explain the difference between mediation, dispute settlement, and other tools of alternative dispute resolution. Understanding these differences is crucial for proper application of all these tools. For instance, in the past years, the National School of Judges together with the Supreme Court, held an seminar on mediation for dispute resolution, which was intended to justices of the Supreme Court, but also to judges of lower courts. And as you may see, our school pays much attention to mediation and alternative dispute resolution, to their development in Ukraine, to the setup of a proper academic framework for training judges and judicial candidates so that they are able to apply the respective skills in a proper manner. Our today's event will be attended, actually is being attended by judges trainers who facilitated mediation training, Larisa Shvetsova, Ella Kataeva. The event is attended by Judge Bertman from the Netherlands. We've known each other for 20 years already, since the time Bert worked as a judge of district court in this city of Zwolle in the Netherlands. So all I'm saying is that the event is putting together professionals in mediation who are ready to share their knowledge and skills for the sake of Ukrainian mediation. Thank you.
Я хочу надати слово представнику проекту ЄС Права Justice, пану Довіду.
And now the floor goes to Dovydas Vitkauskas, team leader of the Prava Justice project. Dovydas is the very same person who launches a lot of positive initiative in the field of justice in Ukraine. Thank you, Luisa. Thank you for having us at this event and for having us participating in this discussion. We are very pleased to be able to contribute to great dispute resolution. In Ukraine, we believe mediation to be a very progressive instrument which has been acknowledged across the world. Mediation is widely used across the world, and I believe this is something which can and must happen in Ukraine, especially considering the workload of courts in Ukraine. Actually, I believe that we do not have objective data on the court's caseload in Ukrainian courts. It's natural. People like complaining in Ukraine or in any other country. People tend to go to court on any occasion, complain and trying to have their dispute adjudicated in their favor at any cost. However, it is not an effective approach because it is what causes a great caseload in courts, which does not allow judges to look into details of really important cases, to prioritize, to go to the core of important dispute. But instead, the judges tend to apply a rather formalistic approach when adjudicating, which is not beneficial for anybody. In this trend is especially noticeable in Ukraine. However, it is not best European practice, it is not best European approach. And again, in European countries, such an understanding has came up a while ago, and there are some countries which can be considered as a very positive example. For instance, Finland. In this country, the number of cases which go to court is considerable, comparable to Ukraine. If we count per capita. However, the number of cases which actually go to the end of judicial proceedings is extremely low in comparison to the overall number of cases. Why so? It's because multiple additional instruments are applied in order to ensure dispute settlement at earlier stages of trial, or maybe at the pre-trial stage. These possibilities apply to various to cases which fall under various jurisdiction, especially in civil matters, of course, which is the vastest field of jurisdiction. The same happens in Lithuania. We borrowed this approach from Finland and other countries with best practices. So in Lithuania, we have a so-called pre-trial stage. We have a preliminary session which is held by a judge where parties are offered alternative instruments for resolving their dispute. It is an approach which is vastly used in commercial cases. In the meantime, coming back to Ukraine, we may want to think about the simplification of procedures for cases which are actually tried within the court proceedings, because many cases are very similar. The amount of claim may differ, but all in all, the cases are very similar. So the procedure may be standardized if you want. These are just some ideas which are partly linked to mediation. Thank you. Thank you, Dovidas.
Now the floor is given to Irakli, head of Georgian Mediation Association. Please, the floor is yours.
Let me greet everybody and wish you a successful conference. It's our big pleasure to be today with you, to organize and be a co-organizer of such an important international event, taking into consideration that the mediation is a total novelty in Europe. At the same time, for us, Georgians and Ukraine, it's real novelty that currently is taking active place in our countries. And it's a very important such an event to have a chance to exchange experience of our countries and European standards. Therefore, I want to thank the Academy of Mediators of Ukraine, School of Judges of Ukraine, Georgian Mediators Association, and other organizers and international donor organizations for supporting such an event as a webinar. And I'm sure that such activities, joint activities, will be the ground for our further development of alternative dispute mechanisms in our countries. Mediation is a ADR. This is a very effective, at least in Georgia, giving a chance to the disputant parties to save time, to save expenditure, and even raise the access to justice and make court system as well even more effective, taking into consideration that the judges have even more time for consideration of general cases and shifting the cases to mediation where the parties reach their settlement that is acceptable for both parties. Therefore, mediation is not only novelty of a legal nature, but this is a novelty that is a ground for social peace in our countries. Therefore, I'm very happy that we have a chance of such international platform, and I'm very happy that Georgian judge as well is participating and ready to share the experience of Georgian court system and role of judges in court mediation. Therefore, once again, I'm ready as chairman of the Mediators Association of Georgia to continue active and fruitful collaboration with my stakeholders and partner organizations in Ukraine, and I do hope that we will have a chance to be participants of such live conferences in Georgia at the same time. I want to wish to each of you a successful day, a fruitful conference, and further collaboration in the best interest of mediation in our countries, and the best interest of mediation in our countries is the best interest of beneficiaries, disputant parties of mediation. This is society, this is business, who will gain as much as possible from friendly, amicable dispute settlement form such as mediation. Once again, let me wish you a successful conference.
Дякуємо, Іраклію.
Thank you very much, Irakli. Indeed, we do hope that we will manage to do that. And now the floor will be given to head of Odessa Commercial Court, Volodymyr Petrov. Good day. I want to welcome everyone with today's event. Mediation is indeed a priority for our work at present, and we hope, as it was mentioned today by Dovydas, that the lion's share of disputes will be taken over by mediators, and finally judges will have more time to, in a more quality manner, consider disputes that will be shortlisted after mediation, if such do exist. But we hope that some of them will be there for us, and it's an introduction, and mediation is a very serious process, and we do need to work on it a lot. We know that there was in first reading a law passed. We hope that it someday will be adopted, and thanks to our international partners. Unfortunately, now we see that it's not very quick, but we do hope that international engagement will provide its streamlining. And I hope that we will be successful, and that we will be able to have a look at international experience, to hear best practices of our Ukrainian this issue. And thank you so much for such a wonderful attention. Thank you so much, Volodymyr. Indeed, we can now start our conference. So today the conference is built of three parts. First part will be devoted to global experience. Our foreign colleagues will be able to share their best practices, how mediators and judges interact. And after that, our Odessa colleagues will be able to share their experience, and they will show that even if there is no legal framework for governing mediation, still such a cooperation can exist. And finally, in the last session, we can discuss issues, what prevents mediation now in Ukraine, what prevents some collaboration. So now the floor is given to moderator of first session. It's to Sofia Vidra, Junior National Expert of Pravo Justice, moderator of the first discussion. Thank you very much, Luisa. Again, I want to welcome everyone who has gathered here and everyone who joined us on Zoom and who is watching online broadcast on Facebook. It's a very good opportunity for me to moderate first session that is devoted to global experience of organizing court next and judicial mediation. And the purpose of this session is to get to know more about models that exist in different countries, to get to know different roles of court that it can play. And I hope that after a presentation of our international experts, we will be able to ask questions that are of interest to us here. And first, we will give the floor to international expert of Pravo Justice Project Marionati, who is a judge and also a mediator. And let's start with Finland's experience. Maria, you are now given the floor. Please, you can start.
Okay, thank you, Sophia. Can you all hear me now? I am, dear colleagues, I am honored to participate in this event. And thank you for all organizations for the opportunity to participate. I had a chance to visit your country in 2019 and had the chance to meet some of you over then, like Louisa. It's nice to meet you again. I was impressed how much is done in your country in the field of mediation. So at the moment, I feel humble in front of you presenting the Finnish system. Now I think we can turn the slides, please. Okay, this is my summary of the presentation. I have several slides here, but some of them are about mediations in which you all are real good experts that I know. So I will skip most of them and try to concentrate on the Finnish experience. So the next slide, please. Here you can see the list of different fields on mediation that Finland is dealing with. So I won't go through these, but I will. I have to tell you that I'm really proud of the peer mediation in schools and kindergartens in Finland, which has been going on for years. This is where it all starts from. Here is where the mindset is being set with the youngsters, with the children and smaller ones, so they know how to resolve their conflicts amicably. So this is where it starts from. So the next slide, please. This is some wise judge from US who you can read it later, who said that so the judicial proceedings are something that we have to leave behind and start to find new amicable resolution systems. In Finland, as many of you already have heard this and know about this, but I will just shortly go through it. In Finland, we have this law on mediation in civil matters and confirmation of settlements in general courts. And it came in force originally in January 2006, and it applies to all civil matters, including family matters in general courts. The objective of court mediation is an amicable resolution of the matters you all can understand. And it requires the consent of all parties. In Finland, the mediation can be commenced whether there is a matter pending or not. So a separate application by parties or one party alone can be filed in the court, just saying that mediation is requested, and not go into the case more than that. But the mediation can be commenced also by referral of other judges. And it can be a joint request or one party alone, and it can also start on judges' initiative. But the court always decides on the commencement of mediation. Next slide, please. In Finland, a judge acts as a mediator in civil cases alone, and in family cases as a co-mediator with an expert. The mediator shall not adjudicate in the same case, of course, and this includes the confidentiality, which I'll go back later. I have to emphasize that judges, every judge who mediates, are trained to work as mediators. In Finland, this is based on CEDRI, which is the Center for Effective Dispute Resolution, their training. And we've had CEDRI trainers in Finland to train us, several different trainings. And in addition to that, some of us has been training in international mediation, cross-border mediation, and etc. But it's important to know that judges cannot mediate without this proper mediation training. And as you know, this is voluntary, facilitated, structured, etc. Different different tools, etc. And I have to emphasize also that this is not conciliation. It's a different procedure, different roles. And so in the beginning, many judges thought that, okay, this is what I do in everyday life, but they did not understand that mediation is a different procedure with a certain structure, etc. And as said before, it's possible to use an expert to assist in the mediation, and the settlement can be confirmed in court, and it is enforceable as such. Next slide, please. Next slide, please. Okay. Next, and still this one. Yeah. So this is just an example about, as you all know, and this is the structure of mediation. So this is totally different than conciliation in court sessions. Just an example. Next slide, please. The mediation in family disputes, it's based on the same law, but mediation should be carried out and the settlement confirmed so that the interests of the child are safeguarded and the provisions in the law concerning the custody of the child are taken into account. So this is not, as said, pure mediation, because this interest of the child has to be taken into account. So the mediators cannot confirm a settlement which they consider against the interest of the child. The objective is to increase settlements in cases where children are involved. And this is co-mediation, as I said before, judge as a mediator and a psychologist, or an experienced social worker as a co-mediator. Both trained mediators. This is something that I cannot emphasize too much. Next, please. We find this a special service that parents may use. And these are the questions so you can understand that almost anything can be brought up when mediation in child custody cases are at hand. Next, please. This I said already before, but mediation with an expert assistance like the psychologist is to ensure that questions that are essential with the regard to the best interest of the child are handled and the settlement reached is in the best interest of the child. These experts are experts in parenting and child development, so those issues can be tackled better in that way. It's based, like all mediation, so this is no use to tell you, but this is based on discussions with both parents. We have caucus sessions and possibility also to talk with the child. And next, please. So this I told you already. So this is, but all the judges who mediate family law cases must be acquainted with family law matters, so that they have to know the legal background as well. And it's always co-mediation, which has been found very, very fruitful and very good way to mediate family matters. It's easier when you have someone to reflect with, and an expert. As I said, I'm a grandmother, so we all have our own experiences on children, but the expertise is theirs. So, and also here the agreement can be confirmed in court by the mediator and valid similarly to the court decision and enforceable as such. Next, please. Costs of the expert, the psychologist, is paid by the state, so it's free for the parties, and there's no extra costs for using mediator as well, because it's judge's duty to mediate in his or her office. So it's just the court fee, which is 250 euros if you don't have a free legal aid. And here again, I emphasize the training of judges and experts to act as mediators. the training consists many different topics, and it's also cross-scientifical. So we have judges get trained in child development and multicultural and diversity and parenthood, etc. And training is organized by the National Courts Administration in cooperation with the Judicial Training Board. This is something that you all know because you're familiar with mediators. So when mediation works, so can I have the next slide, please? So this I said that you are all familiar when mediation works, so because you are familiar with and experts in mediation. So the next slide, please. These are the possible, next slide, please, yeah. These are the possible obstacles, but you are aware of these as well, so I don't have to go through these. So you can read them later if you agree or not, but then these are the typical obstacles in mediation. I believe you are also aware of benefits of mediation for these are the benefits for the parties. So save times, lower costs. So the next slide, please. Okay, here. And these are the benefits for the clients, the parties, which you are all aware of, I'm sure. So save time and lower costs. Can I have the next slide, please? Next slide, okay. And these are the benefits. It continues. So flexibility, less stress, and forward-looking focus on the future. These are the benefits. Next slide, please. And here also the satisfaction and finality and confidentiality, as you all know. So please, the next slide. The benefits for the courts. This is something that we already heard the previous speakers to mention. This saves resources. In Finland, we have proven reduction of courts caseload, the number of cases and hearings, writing time of reasonings, etc. And it really eases the workload of a judge. We have shorter cycle of cases, and it shortens the average time cases are pending in the courts, can end constant, never-ending litigation, spiral of trials, as we call it. The judges, when we started this, some of the judges were opposed to this and thought that this is not the work of judges and courts. But this has changed. Nowadays, we see the courts more as service providers, and we have to think who we are for. Are we for ourselves? Are our status, the court's status, and in the society, or for the people? For example, in my court nowadays, we are about 40, a bit more than 40 judges. Everyone except the youngest new appointed judges who have not time yet to go through the training. Everyone is trained. And there still are some judges who don't find it very comfortable to mediate, but everyone refers. And everyone believes in the system and sees the benefits for the court and for themselves as well. But most of all, to my mind, so we are believers in this system in the courts of Finland, and it's very effective, like we heard already. The Private Justice Team Leader say. So this is effective, but most of all, as I pointed out, who are we for? We are here for the people. So this is really good for them. So I have been working as a judge from 1990. So believe me, I know this is better for the parties. This is better for the parents. This is better for the businesses. This is better for the children. So what I want to still state that it is important that the support comes from the management of the court. The head judge believes in it. So it's, like I said before, that the state of mind has to start from the childhood, but then when we are already here and the courts are functioning, so the support must come from the head judge, and so he or she also must be a believer, so that this is really effective. So I encourage everyone to believe in the method. Next slide, please. So quickly, these experiences. So more than 50% of family law cases are referred. Today, more than 50% of all cases are direct applications, and more than 80% of civil cases settled. So this means the construction disputes between businesses, whatever. And then over 60% of family disputes end up to an agreement. And here we don't like to talk about successful mediation. That means that only a mediation in where we reach an agreement would be successful, because we believe that something during mediation, something happens and people try to think more. So our experience is that even though no agreement is reached and the case goes back to the court proceedings, the parties very, very often come to an agreement before that. So in general, the court users' experiences are very good. We collect feedback all the time, and judges commonly find it challenging, but very, very rewarding. And so it's sort of, you never get a thank when you sort of give your verdict, and the other one of the parties, or mostly both of the parties, are not really satisfied. But after this, people might even hug you and thank you, and they can move on with their lives. I have this work supervision here, but then I can talk to you about later. I must emphasize this as well, that it's very important to distinct the roles, the judge and the mediator. Like I said before, it's not conciliation, it's different procedures, and mediation follows, as you know, a certain structure, certain techniques and tools and so on. Then I will not tell you about, but we have facilities for these different facilities. We don't mediate in our courtrooms. And about the tools, I don't have to tell you because you are experienced mediators. Can I have a next slide, please? So this is one of our mediation rooms. We offer people coffee, beverages, chocolate, biscuits, and etc. And then we have smaller separate rooms for caucuses and for the parties to talk with their lawyers. Next slide, please. So judges has been acting as mediators for more than 14 years now, and they still are acting, like I said before, judges in other civil cases and as criminal judges in their courts. Confidentiality is really important, so this means not only in the actual case, but we don't talk about these cases among us judges. So the confidentiality stays in the mediation room. Our experience also is that mediation or experience as mediators helps judges to work also as judges, and this is without mixing the roles, but it has helped us to listen more, to do the active listening in the court proceedings as well, etc. And as said before, it's absolutely better for the parties and the families, and especially for the children, than the court proceedings. And as said before, it's better for the courts, it's better for the social field, it saves resources, etc. So can I have the next slide, please? This is the cover of our brochure that we send to clients every day. When we have a different in civil mediations as well. So every time we get a case filed in the court, we start with asking their permission or their willingness to mediate the cases. So we send these brochures and tell them about mediation. So no one of Finnish parties who have a court case is able to sort of skip the information of mediation. So this is, next slide, please. So this is one of my favorite donkey conflict. This is just to cheer you up. Then I have, next slide, please. I have, next slide, please. So here are some links for you. I don't go through them, but there's a few articles about the system in Finland and etc. and the brochures and that. So next slide, please. So I thank you for your attention, and I'm ready to answer your questions in the end of this session. Thank you very much.
Дуже дякую, Мар'я. Насправді цікаво дізнатись про таку абсолютно незвичну модель для України, коли суддя може бути і медіатором при суді. Також цікаво почути про особистий досвід Фінляндії, як Мар'я зазначила.
Thank you, Mario. It has been indeed very interesting to hear this very unique experience where judges may act as mediators. Interesting to know that such an unusual approach provides quite good and positive result. And now we will proceed with the Dutch experience with the help of Bert Mann. Bert is a former judge and an international expert for quite a long time. Bert is our long-term friend and expert to many other international projects. Bert, if you're ready, then the floor goes to you.
Thank you very much, Sophia, also for your nice introductory words. And I already see my my slideshow on the screen. Good afternoon, everyone. I wish you quite a success in this very interesting event. And it's lovely to see Volodymyr again after a few years, but I was happy to see him again in good health. As this is a part about my background, but which I will not dwell about too much, but you can also see that I also have some experience as a judge. But particularly, I would like to point out at my period as the president of a first instance court in Zwolle, to get an idea what kind of court it is. It consisted at the time, let's say about 80 or 90 judges, with about 400 or 500 people staff, so quite a big organization. The next slide, please. In my speech, I will give several aspects. First of all, some general remarks about what is the purpose of law, something about the arrival of mediation to the Netherlands, something about gaining and keeping the support by judiciary, an organizational approach, and a few words about the present situation. And then the next slide, please. Sometimes during conferences and so on, when it's appropriate, I ask my lawyers, attorneys, my audience, what is the purpose of law? and then it gets a little bit silent, and people say something, bring order or clarity or something like that, and of course that is true. However, at the end of the day, and to a certain extent, Mario also referred to that, the purpose of law is aiming at restoring or bringing or keeping peace in society. At the end of the day, that is the purpose of law. Next slide, please. That reflects to what you see in the legal culture in my country. As you probably know, this country was, first of all, gained against the water, the sea and the rivers, so people are used to cooperate if they want to survive. From the 15th, 16th century on, we have been trading a lot internationally by our ships and so on. And trade is something else than making difficulties. On the contrary. We say in the Dutch, if you want to understand the Dutch people, you must remember one thing. We buy cheap and we sell expensive, and the expenses should be as low as possible. And complications, fights, disputes cost money, cost time. That is not good for business. So what you see as a character of doing business in the Netherlands is to prevent and solve disputes as soon as you can. In other words, you will find a solution-oriented approach to all kinds of conflicts. And that reflects to a certain extent also for the professional rules, the codes of conduct of attorneys, where it has changed now a little bit, but it's basically the same, where it says every attorney is obliged, before he goes to court, to try to find a settlement for the dispute. Secondly, in the present civil procedural code, you will find a provision saying that judges are allowed to, and they use this possibility very often, allowed to determine a hearing, to call parties to attend the hearing and try to find a settlement. As I said, this is used rather often. Next slide, please. Then comes the arrival of mediation. When I was a court president between 92 and 2006, one of my judges, an administrative judge, came to me and said, Bert, you know, in America, they have very new ways of solving problems. That is called mediation. And I am convinced that we can solve all the problems, all the disputes that we have in court by the ways of mediation. She was one of the, what you can say, true believers. And also Mario referred to the true believers. And I must admit, I am not a true believer. But I believe that mediation is really a very important and useful tool to solve problems in a more structural way than just giving court decisions. In that sense, I am a believer, but not a true believer. I think we need both. We need courts, we need lawyers, and we need mediators. And here I would like to emphasize, and Mario already said the same thing, let us keep in mind that mediation is totally different from reconciliation and settlement. For the discussions, I think it's useful to make this clear distinction. The next slide, please. This judge convinced me that it would be useful to start something like an experiment on mediation. Basically, it worked like this, that whenever in the administrative procedure a request, application was done, the applicant and the other party received straight away an invitation and saying, if you want to, you can enter into a mediation process, and let's try to do that. For all kinds of organizational reasons, it was not very successful, but those mediations that came from this experiment worked rather well. So it gave rise to further experiments in all kinds of local areas, and you find it in Zwolle, in Arnhem, Assen, and other places. Judges, courts are allowed to do everything what is not forbidden. That's the difference between our country and some other countries. So after these experiments, there came a project set up on the central level, because we said you cannot have a court totally different from a neighboring court. So on the central level, they created a project organization for the benefit of creating support for mediation by supporting the courts in terms of organization, organizing training and education of judges and other people, but mediation is to develop an information and a communication policy and so on. This project was finished about 2005, 2006, and since 2007 there is a common existing situation dealing with promotion by the court system of mediation as from 2007. The next one. And what is this situation in fact? In fact, it works like this. And maybe our courthouses are a little bit different from ours, but mostly our courthouses are rather roomy, space, quite some space. And in the entrance area, you will find an information desk where you can deal with most of the aspects for which you visit the courthouse, producing documents and these kind of things. Such an information desk is supporting the mediation officer, and each court has a mediation officer in her or his work. A mediation officer is not a judge. It's often a judicial assistant who has received quite some training in mediation, knows what it is, and knows how to talk with the people. As I said, not a judge, but often a judicial assistant. Both this person and the information desk have a list of mediators who are able and willing to perform mediations which are referred to them by the court system. This is quite a long list with specialization, family law or neighbors or commercial or whatever. They give their specializations and so on. And when parties and their lawyers want to go into a process of mediation, the role of the mediation officers is to show what's possible, to establish the contact between the mediator and the parties, and to make a first appointment for the meeting. The first meeting, according to this system, is free of charge. For the rest, you have to pay that. With that restriction that people who are subject to the system of free legal aid, they will have a mediation free of charge, which in family law cases is rather often the situation. And what you can understand, that the judge, according to law, is allowed, has the power to adjourn a hearing, the case, and suspend the trial in order to attempt mediation. How does it work in practice? Because sitting as a judge, both in Amsterdam and in Zwolle, I experience it quite often. So you listen to parties, you listen to the attorneys, and at a certain moment you think as a judge or as a court and say, you know what, this might be something which gives a better solution when we try mediation. You can say, ladies and gentlemen, did you think about in your situation that mediation might be a solution? So you ask them, and they are able to say something, oh, I don't want this, and if they don't want to, it does not have any use to start mediation. But if they are inclined to do so, they say, okay, let us adjourn the hearing for a second. I will call the mediation officer. I'll ask the clerk to call the information desk that you will be coming, go down to the information desk, contact the mediation officer, and make the first appointment and so on. That's how it works. People come back afterwards and say, well, we are going into a mediation, and the court will say, okay, then we'll adjourn the hearing for 2 months, 3 months, depends on the situation. And then mediation can start. The next one, please. That's about the practical thing. But that's not enough. You also have to provide for an information policy that all kinds of things are simply accessible, that people know what they are doing. And mostly what you see now, there are brochures in the courthouses, but mostly people use nowadays either through a laptop or their cell phones, the mobile phones, the brochures on websites, and there are 4 of them presently on general information. One of them in divorce and family law disputes. Indeed, already Mario referred to the children custody disputes, which are very complicated often. There's a brochure for administrative disputes and one for civil disputes. So the criminal area is a little bit different. You can also find all the information efforting on criminal cases and mediation on the website as well. The next slide, please. And we try to be, wait a second.
Next slide, please.
Yes, that is the one.
On
the website, you even find a self-test, because of course, it is no use to try mediation when you are not inclined to do it, if you are not able to find a solution, a peaceful solution. So you'll find the self-test on the website of the judiciary website, saying and asking questions: do you see possibilities for a reasonable solution? And if you say no, don't try mediation. Or I have to deal with my counterpart more often in the future, which is a strong point of mediation, that you do not solve the problem just at hand at this moment, but also for the future, because you have to deal with these people more often. Or you say, I want to have influence on the outcome of the conflict. Or it might help to solve not only this conflict, but I still have a few others. You can go through this self-test, and if on the basis of this self-test, you can see for yourself if it is a useful idea to enter into a mediation process. The next one, please. Then you have to say, what are the results? I found quite a few reports, of course, and they never answered the question that you want to have answered, but that's another story. I found a report from 2009, 10 years ago, 11 years ago, which said 3,700 judges, cases have been referred by judges, and 90% effectively started. The average of the satisfaction of the people was 8 out of 10, so they're rather enthusiastic about it. And in terms of solutions, in the contractual disputes, they found 58% successful, divorce and family law 44%, and conflicts between neighbors, who are rather frequent, it was 32%. The next one, then I found a more recent report, 2018, in which year almost the same number, interesting, almost 3,700 cases referred to mediation, of which in family law cases about 2,000, almost 2,000. Also there I found some information about penal cases, settlements between the victim and the perpetrator, influencing the consequences in the penal situation and the penalty. There were almost 1,500 cases, of which 80% was successful. The next one, please. A few additional statistics about the number of mediators in the Netherlands. It's almost 3,000, as you can see on the slide. And the number of mediation performed by registered mediators was about 51,000 cases. And there you see the percentages: 45, 54 family law, 22 in labor law, administrative law only 4%, should be more, and conflicts between neighbors about 7%. Next slide, please. Some additional statistics. The referrals to mediation, so went from the side of the mediator, you say, who did refer the case to you? 23% was done by judges, and 29% was done by attorneys. So also attorneys see mediation as a real option. You ask the people, are you aware about mediation, what it is, and does it exist? And we say that 14% are well aware, 31% is reasonably aware and 30% has heard of it. So you can say many people know more or less about mediation. Awareness of mediation is an aspect for its popularity, I suppose. And are the people satisfied about mediation? 44% are satisfied, 25% find it even good, and very good is 13%. So you can see that is quite successful. The next one, please. Which are the results of the mediation, wholly or partly? In family law cases, it said in 2019, 65% was successful. In the labor disputes, 73%. In administrative cases, almost 80%. And the conflicts between neighbors, it was 74%. You can see the next slide, please. It looks as if there is a relatively small percentage of cases. That might be so. I think from the contentious cases of court, not many more than 5, maybe 6% will be finished by mediation. Still, you cannot measure what kind of procedures are prevented by mediation, because that is what it works out. It prevents conflicts, it prevents escalation of conflicts, and prevents all kinds of new disputes. On the other hand, when 5% of the people involved, and you should add, in fact, say that's almost 10, because with a mediation you always have 2 parties at least. When this percentage of people are involved in mediation and are more or less satisfied, that is an important issue for the whole atmosphere and the culture in the country. The next one, please. The lessons learned. What we have found in the Netherlands, and I hear the same thing from Finland, promotion of mediation is a good way to solve problems by courts and judges. Gives it a place, it gives you respect, and it allows people to say, indeed, that might be a suitable solution for solving my problems, my disputes. Promotion by courts and judges are important. And I remember when I talked about this judge coming to me in the mid-90s about being a believer in mediation, she also said, beware, if the courts are not taking mediation serious, it will never be a success. And I think she was right. That's why I say judges and courts play a very important role in terms of suggesting and promoting mediation as a serious issue. Judges are only human, and something was said about this by Mario as well. Judges will only refer to mediation when their presidents, when their senior judges, when the higher authority in judiciary are in agreement about that they also think that the judge may and should even do that something. Mediation is one of the ways to increase a different culture in society, moving more to settlement and mediation and peaceful solution, moving away from a system of winning and losing. And thirdly and lastly, it is important that mediation to be taken serious is well facilitated. First of all by the courts, also by the systems of free legal aid. Mediators can be paid by the state according to that system. And it is offered by services on local and municipality level, particularly when you deal with neighbors and so on, because they are. This, ladies and gentlemen, is what I would like to tell you about the experiences in the Netherlands about mediation. The next slide will say, Děkuju. Duže děkuju. Thank you.
are some technical challenges. The service providers are trying to set the sound working.
Дуже дякую, Берт.
Thank you very much, Bert. Sorry for delay. We had some sound challenges. Netherlands experience shows how much important it is that courts and judges take an active part in this situation. And we see that there are models when a judge can decide whether engaging mediation is feasible. Bert, thanks a lot. By the way, all presentations by our international experts can be found at Bravo Justice website. They are in English and Ukrainian, so you're welcome. And now I propose that we hear about Georgia's experience that will be presented to us by Tbilisi Court. Tina Avashahmadze, please, the floor is yours.
Good afternoon, everyone. It's a great honor for me to participate in this seminar. My name is Tina Avashahmadze. I'm from Georgia and I'm judge in Tbilisi City Court, Civil Division. I'll make a brief overview about mediation and this process in Georgia. Recently promoting the development of alternative dispute resolution tools has become one of the most priorities of our country. Everyone should be able to apply for ways to restore their violated rights, which are tried in developed countries of the world, to spend less time and spend less financial resources. The purpose of mediation is to promote alternative dispute resolution, increase access to and efficiency of justice, and maximize the relief of the judiciary from disputes that have the prospect of being settled by mutual consent. In addition, the flexible mediation rules makes it possible to use this opportunity in combination with other disputes, with other dispute resolution tools. This once again emphasizes the role and importance of mediation in achieving a common goal. The mediation process allows the parties to better understand both their own interests and each other's interests and needs. It focuses on finding solutions that are beneficial to the both parties. As a result of mediation, an agreement can be reached only if both parties agree. And what about Georgia? The association agreement between the European Union and Georgia and the association agenda define the obligation of the state of Georgia to develop alternative means of resolving disputes, especially mediation, to create favorable conditions for their use. The formal establishment of Mediation Institute in Georgia started in 2011. Over time, the legislation governing the Institute of Mediation has experienced variability. According to the amendments to the civil law from 2020, mandatory court mediation came into force together with the voluntary court mediation, according to which judges, after assessing the circumstances of the case, have the discretion to transfer the case to a mediator, including without the consent of the parties. According to statistics, in 2020, more than 50 cases have already been transferred to court mediation, which reviewed the Association of Mediation, and most of them were successful. Important news regarding private mediation upon the request of the parties to the application to the court, it's already possible to enforce the agreements reached. After the enactment of the law of Georgia on mediation, the first settlement of the labor dispute between the parties was held in a non-judicial mediation format. The court examined the legality of the settlement act reached between the parties, the possibility of its enforcement, and made the decision on the enforcement of the settlement agreement. And what about proceedings according our procedural law. The mediation mediation period is 45 days, but not less than 2 meetings. The term provided for in may be extended by agreement of the parties for the same term. After the transferring the case to the mediation, the court suspends the proceedings. If the dispute is not resolved with the time limit established by law for the mediation of the parties, the plaintiff may apply to the court with a request to resume proceedings. If within 10 days of expiration of statutory period for court mediation, neither of the parties, in accordance with the paragraph of this article, request the court to resume the proceedings, the court shall issue decision to leave the claim unconsidered. This is the brief overview about our mediation process in Georgia.
Дуже дякую.
Thank you, Tina. Georgian experience proves that approach to mediation can be quite flexible. Thank you for this presentation, and I think that now it's time to sum up this session and say that international experience proves the possibility of existence of various models of mediation. The statistics in all cases proves that mediation is a relevant and expedient tool and may bring good results. We can also notice the importance of the support from the judiciary and importance and significance of mediation for greater access to justice. And now it is time for questions and answers. All the participants may ask questions online or offline. Please raise your hands physically or via Zoom functions. If you have a target question to a particular speaker, please indicate that when asking your question. Are we having any questions so far?
Так, якщо в Zoom також питань немає, тоді я роблю висновок, що презентації були повністю вичерпними.
There is no question either online or offline. I can resume and presume that the presentations were exhaustive. I'm grateful then to all of our speakers, highly respected speakers, and let us move forward to our second session. We are going to talk about piloting of mediation in Odessa, and the floor goes to Svetlana Sergeyeva from the Ukrainian Association of Mediators.
Доброго дня, колеги. Дякую, Софія.
Good afternoon, colleagues. Thank you, Sophia. My pleasure to greet everybody at the event. Prior to the launch of the second session, I have to say that the sequence of interventions during the second session is directly related to the sequence of opening of cabinets of mediation in respective institutions. I'm very grateful to all the adepts and believers in mediation from among Ukrainian stakeholders. It's thanks to your proactiveness that the cabinets of mediators could have been opened in various courts in Odessa. Your proactiveness is inspiration for your colleagues across Ukraine. Currently, all the cabinets of mediation in the city of Odessa cover all jurisdictions. The first cabinets were opened of mediation were opened in Odessa in February 2018 in the framework of an international project. There had been other projects on mediation previously, but courts had never been engaged. In this connection, I'm very grateful to judges from the first instance and appellate instance for having believed in us and having agreed to launch this initiative from scratch. It's extremely positive that judges believe in other ways of dispute resolution, except for alongside judicial trial. Marina Mishkina will tell us about it in more details. I will now pass floor to her. After having listened to international experts, we restated in the idea that mediation is a very popular tool in European countries and is a major tool to settle disputes. Ukraine, as a country which undertook and opted for a pro-European way of development, has to eager to adopt such best practices. Our court was indeed the first among commercial courts to launch mediation. I think that chief of staff of our court would be in a better position to talk in details about this initiative. Thank you, Marina. My name is Anna Pavlevska. I'm chief of staff in the Fifth Court of Appeal located in the city of Odessa. Opening the cabinet of mediation was a great responsibility, but all in all, we accepted undertaking that cabinet, and we realized one thing. It turned out to be much easier than we could expect. So what the court needs in the first place is a spare location, a spare room. The size doesn't matter. The equipment is very primitive. A table, chairs, some minor decoration in order to make it look more vivid. What else is needed? Some public outreach. You need to inform people. In our court, the cabinet of mediation is in place for 3 years already. We've been supported all along the way by the Ukrainian Academy of Mediation, and it was indeed a great deal of support, which is very valued. We couldn't expect the result that we've achieved so far. So initially we thought that the Cabinet of Mediation would be more destined to parties to proceedings. So basically parties to trials taking place in our court. However, it turned out that we started having people coming from outside. And all in all, the Cabinet of Mediation became very popular. It was indeed very inspiring because we can hear from everywhere about low trust in the judiciary in Ukraine on one hand, but on the other hand, people tend to opt for court-annexed mediation. So people basically trust in mediation more if it happens in the premises of a court. So again, we are very grateful to the Ukrainian Academy of Mediation. Speaking about categories of cases mediated, they are mostly family cases, car accident disputes, contract disputes, supplies, rent. After the mediation, it seems that after successful mediation, both sides seemed more satisfied in comparison to a regular court trial. Lawyers played an important role in the facilitation of mediation. After having achieved agreement in the framework of mediation, lawyers would address the necessary formalities to close up proceedings. Of course, the legislative framework is not sufficient, and the procedure of mediation is not quietly streamlined. There is room for improvement, which is acknowledged by parties, by lawyers, and by judges. Some ideas are already there. Some amendments to procedural legislation have been developed so that mediation could be naturally incorporated into the judicial process, and so that judicial process could be suspended if necessary. All in all, mediation is a huge step forward. It's a bond forward. That is why we would want our experience to be rolled out across Ukraine. Should they need any support, any advice, we are there, and we are ready to share our way and tell where we began and what must be done first. We produced quite a lot of materials covering this experience of mediation in our court. I'm talking about printed handouts, about videos, some promo campaigns, small ones, but sufficient to reach out people, at least in Odessa city, and inform them about this new possibility of addressing their disputes. Thank you.
Дуже дякую, пані Анна, за
Thank you, Anna, for your presentation of the Cabinet of Mediation in the Fifth Appellate Court. First instance courts are on the front line because this is where parties go first when they launch court actions. While big players, big business players are already aware of mediation, small and medium entrepreneurs and businesses are much less aware. So it's great that some outreach campaigns intended to small and medium enterprises have been launched by first instance courts. I'm now given floor to Julia from the first instance court. Hopefully you can hear me. Julia is saying.
Так, пані Юлія.
Доброго дня. Доброго дня, шановні колеги, шановні учасники нашої сьогоднішньої.
Good afternoon, dear colleagues. My name is Yulia Bezdolia. I'm a judge of the Commercial Court of Odessa. Thank you for having me here. I'm grateful to the organizing partners, Ukrainian Academy of Mediation, National School of Judges, Court of Appeal, and our Justice Project. I will speak today on behalf of the Commercial Court of City of Odessa. We piloted the implementation of mediation in commercial jurisdiction in Ukraine. Ukrainian mediators has been struggling for many years for greater legislative governance of mediation in Ukraine. Judges are also very much in favor of the development of mediation. In the meantime, there are multiple discussions around what the role of a mediator should be, about who can be a mediator, and what the scope of functions of the mediator should be. I'm fully in favor I was fully in favor amendments to the procedural code, which envisaged the possibility of reconciliation, of judge-guided reconciliation of parties, which has been perceived by many as mediation. However, people who are close to mediation understand that mediation and reconciliation are two different things, and basically our international experts and partners mentioned the importance of understanding of this difference. For instance, Mario Napi, a Finnish judge, can also act as a mediator, as she said, but she underlined on multiple occasions that her roles and scope of powers as a judge and as a mediator are not the same. In Ukraine, we're still awaiting for the mediation law to be passed. The major thing which impedes a successful implementation of mediation pilot is the lack of procedural regulation. For instance, in certain cases, it is impossible to basically incorporate mediation into the judicial process. That is why they are happening in parallel, which at times brings about multiple problems relating to the respect of procedural terms. Speaking about the link between court annexed mediation and judge-guided reconciliation, We held only 6 court annexed mediation, which is not much. However, I believe it to be the first step, as our expert from the Netherlands said. In the Netherlands, it took 6 years to implement and expand mediation. In order to ensure great application of mediation, some legislative amendments are needed, and once the law on mediation is passed, the respective procedural amendments need to be incorporated. For example, currently it is impossible to suspend a trial in order to go for mediation. So, I think this is something that needs to be addressed in law, so that judges could basically use this tool of mediation. If Private Justice Project is willing, it may consider the possibility of providing support in the promotion of the respective legislative amendments. I think that the procedure may be very similar to the procedure applicable in case of judge-guided reconciliation between parties. If the project succeeds, if the amendments are successfully passed, it would be extremely important and it would be indeed a win-win approach to dispute resolution.
And the real protection of rights and interests and the facilitation of a conflict. It's the biggest advantage compared to trials, where unfortunately now, because of difficulties in some precluding aspects that allows enforcement of court judgments, most complaints to the ECTHR is that the deadlines for trials are violated. It's non-enforcement. It's non-enforcement of judgments. It's the biggest issue, and it means that in mediation, fortunately, when both parties are interested in positive result, there is less problem, and that is a big advantage. And Svetlana told that we are limited in time, and I will very briefly tell about drawbacks. Drawbacks are non-regulated framework. We work with National Academy of Mediation. We trust them and we respect them. And when we propose to case participants use expert assistance of Ukrainian Academy of Mediation, we will be sure of a result that because we trust this institution. But because we don't have registers of mediators, if we don't have control over mediators' activity as a judge, I have very important points that need to be governed. It's issues that mediators' activity should not lead to horrible ramifications as we had with magistrates' courts, because magistrates' courts were advertised as good conciliation, as facilitation, but there were some issues that prevented it. And in my opinion, we must understand that private justice maybe should concentrate on work with judges so that we deal with these issues via transparent registers, because in many cases professional advocates, professional attorneys at law they are like mediators as well, and that's a little bit comforting factor for judges that confidentiality will not be breached and that there will be professional assistance. And the last point that I wanted to say, it's about overlapping of procedures. I, as a judge who is very positive towards mediation, I think that in Ukraine we shouldn't fully reject some sort of joint mediation and procedure. I guess that Ukrainian Academy of Mediation maybe could consider this issue, as well as EU Prava Justice project, that in our pilot courts activities and in finalization of our pilot activities, maybe we can try to do joint procedures when there will be some mediation sessions held by court to raise awareness of mediation, and so that parties trust, like maybe it's done with participation of a judge, and maybe later on this trust will be increasing step by step, and maybe we will be able to make sure that it's professional, and it will be very much helpful to our main goal, human rights in every separate case. Thank you so much. Thank you very much, Yulia. And we are moving on. And we go to a very interesting experience of Kiev Regional Court of Odessa, where mediation office became an integral part of civil center justice. And this will be told to us about Judge of Kiev Regional Court of Odessa, Oksana Korolenko. Thank you. Good day, dear colleagues. I'm Oksana Korolenko, Kiev Regional Court of Odessa judge. First of all, I want to thank all organizers of the event for the opportunity to participate in such an interesting exchange of opinions. And in support of what Yulia has said, as a judge, I want to support all that has been said, and I want to say that mediation is very important for judges of first instance, first of all. Today we had a general session of judges of Odessa region, where deputy head said us that overall workload is 109 cases per month, and our European colleagues are very much surprised that we are that much overloaded. And that's why participation in these projects will help us a little bit decrease the workflow. And I'm very happy that in 2018, on the basis of the Regional Court of Odessa region, we have a mediation office that enabled case participants have recourse to mediation to try to have recourse to professional mediators. And 152 persons came to such mediation office. Out of them, 73 came again. And we also had 10 mediations, and we filled in 49 applications. And the Cabinet of Mediation Office was visited by foreign colleagues with whom we had a chance to talk and to share our experience. Within the project all over Ukraine, we had trainings for lawyers and judges. There were separate judges for pilot court judges, because mediation, it's a new term for people. That's why it's judges who should know how to propose mediation to trial participants, at what stage of procedure, in what manner. And also in our court, we had social surveys, both from visitors and citizens who already used mediators' services. As of 14th February 2019, we had Civic Center of providing legal aid, and as of that time, more than 2 years, in our center we have mediators, and they provide free legal aid to Odessa citizens and Odessa region residents. And as of now, there were 16 mediations in Civic Center, and 13 of which are finalized, and 3 of them are still ongoing. And in addition, we had heritage cases, neighboring cases, and family cases, and labor cases, and this gave us an opportunity to see the chance to de-escalate social tensions. And age of users was 35-45 years, and some of the case participants were before trying to consider their case in court, and after their recourse to mediation, they did not go to court again. We engaged professional mediators in course of it. One of them is permanent staff of our civic center. Second one is a volunteer, and mediators are engaged within framework of memorandum with the Ukrainian Academy of Mediation. And we had many trainings from Mediation Academy, and both our center staff and core staff had a chance to have a look at mediation principles and get qualified consultations. The court got 4 cases to be settled via mediation, and so far we see that parties who have been through mediation procedure came back to court, so we did not settle it finally. And in absence of a legal framework for mediation, we do have a problem with low awareness among citizens about mediation procedure. That is, our publicity knows that to settle a dispute, they must go to court. And our duty as a court is to explain to citizens that their cases can be settled via different venue. And on the 25th of January 2021, on the official website of Kyiv Regional Court of Odessa Court, we had an option for online settlement of disputes. It means the matter is that as of 2018, our court is engaged in USAID New Justice project with cooperation with the High Council of Justice, and we are now working on introducing first online platform that will help citizens quickly and conveniently get all the legal aid necessary to settle their cases and for making respective motions. And now we are integrating this platform, and we have registered this platform for mediation services. As of now, only some categories of cases are proposed to be considered therein. It's challenging police's documents, and it's dissolution of marriage when one of the spouses has to do it in trial, and also for child maintenance payments. So then we will have a button to go to mediator, and such option already exists. We are moving forward, and we are not stalling, and we hope that our cooperation will be beneficial. Thank you, dear colleagues. If you have any questions, feel free to ask them. Thank you very much, Oksana, for your experience. We are moving on. An important and valuable is trust that mediation is successful, taking into account difficulties and peculiarities that are related to situations when an authority is part to a dispute. And that's why in the 5th Appeal Administrative Court we had mediation office opened, and now I want to give the floor to the driving force in promoting mediation, judge of the 5th Administrative Court, Larisa Zueva. Good day, dear participants. Thank you for such inspired announcement of my address. I guess I will be the only one, and I will have my colleague too in this next session on administrative justice. Very often, when we hear administrative justice, we hear it's impossible to, in administrative proceedings, use mediation, at least in Ukraine. And I want to say that my main idea is impossible is possible, and we are proving it every day in our court sessions. Odessa Appeal Administrative Court and Fifth Appeal Administrative Court, in which it was reorganized, they were never included in pilot projects, neither in conciliation or in mediation, but the first day when we opened a new building of our court, on the day of its opening, we signed a memorandum with Ukrainian Academy of Mediation on cooperation. And two judges of administrative justice jurisdiction, me and my colleague, we had trainings for all Ukrainian judges, because it's all happened that we were trained at German Academy of Mediators. We are mediators, and we have huge experience in conciliatory proceedings, in particular mediation in judiciary. For me, a very interesting point was situation that happened on a weekend. I was lecturing for Kazakhstan colleagues related to introduction of mediation. It's the only republic of former Soviet Union in which there is no administrative code. They are only now adopting it. And mediation in this country has been in place for quite a long time, and they have a big mediators community. For them, it's much easier now to start this mediation in court because it's already developed, and people know about it. And I want to tell that information is important, information that is brought to people. It's important how people are informed about the possibility of mediation. On the website of the president of Supreme Court of Kazakhstan, there is appeal that before going to court, you should think about conciliation. They have a separate chamber in the Supreme Court and special judge who does not administer justice, but who proposes and who promotes mediation into judiciary. And in e-system that enables filing claim before going into system will not let you in unless you read information about possibility of mediation. Now I'm speaking about our neighbors, and for me it was very pleasant that in many countries it's promoted and developed. And in respect of administrative experience, we have some positive aspects. First is that administrative code of Ukraine that existed before it was amended and codified in 2016 when all the codes were unified. It was a very progressive code. We are the youngest jurisdiction. It was built on a German administrative law system, and mediation has been there for a long time in court in particular. And in code we also always had such an article as possibility of conciliation with parties, not a settlement agreement, but conciliation. And now in conciliation procedure, parties can conciliate in different ways. They can agree themselves, they can agree via lawyer, they can do it via judge. Judge has such an opportunity, and they can ask for mediator's assistance. And here there are two options. Either they do it in court proceedings to help judge finalize it quicker, or they can do it outside court before they even reach the court premises, or they can, when they are already in proceedings, they can ask for some sessions with mediator outside court. But it always impedes communication, and it's very good when under court we have such opportunities. We have two mediation offices in our state. It's only Odessa option. It can only happen in Odessa, that when in administrative appeal courts we have on weekends mediation sessions, and people come to us and we give an opportunity to have mediations in cases that are not related to administrative jurisdiction, because it's our common cause to help all the participants in some way to have less court disputes and to have more conciliation. And as to administrative justice and as to mediation, for that we need to have some procedural code amendments when it's written that conciliation can take place only if an authority acts within delegated authority within Article 19 of the Constitution of Ukraine. And very often authorities say we don't have such powers, we can't do it, we cannot do it, and it's rather excuses than willingness. And where it's possible to have it done, there are many examples. So in the register of judgments, when authorities make some amends with the plaintiff, in particular as first instance judge and appeal judges, because nowadays a lot of people think that it's impossible to do it at the stage of appeal. They think it's possible only in first instance, but the overall principle is that it can be done at any stage, in particular when enforcing.
Спору можна провести лише на стадії першої інстанції, до початку розгляду справи по суді.
However, unfortunately, currently the law says that reconciliation is only available at the pre-trial stage. This is something that we are trying to address, and I know that many of my colleagues support the idea of granting the possibility of reconciliation at any stage of proceedings, even at the enforcement stage. I personally have been dedicating much time to reach out my colleagues and other people and tell them about other possibilities alongside court trial. For instance, a couple of days ago, we've held event where we explained the benefits of mediation to other judges. I believe that mediation is a proper application of mediation is extremely important in administrative jurisdictions. Civil cases are about relations between individuals, while administrative proceedings is about the relations between an individual and the state. And it is very important for the state to be able to show its human face. It is important for the state to demonstrate that it is open to dialogue, that the state is there to help an individual out rather than oppress him or her and go till the end in the framework of court proceedings. So all in all, I believe that enhancement of mediation, including in the administrative jurisdiction, will not only be beneficial to greater dispute resolution, but also for the improvement of the image of the state in the eyes of the society. Let me also remind that in Europe there is a KPI for civil officers on efficiency and performance of a civil officer. And according to that KPI, if a civil officer let a dispute with an individual go up until the trial resolution, it means a low index of the respective KPI for such a civil officer. And then if the civil officer fails to show up at a trial, it may give grounds for the adjudication in favor of an individual, and it is very bad sign for performance of the respective civil officer. All in all, I hope that such an approach and perception of the civil servants, civil officers' effectiveness develops in Ukraine one day, and I hope that people understand that mediation is there to improve lives and make lives easier for things easier for everybody. Thank you, Larissa, for such an inspiring intervention. Let us move further. Unfortunately, the COVID-19 pandemics slowed down many activities, and what we planned to do last year became possible this year only. In Primorsk District Court of the city of Odessa was planned to be opened last year. However, it was opened recently, a very short time ago, and I'm now pleased to give floor to Andriy Lysenko, representative and judge speaker of the Primorsk District Court of the city of Odessa. Thank you. So we had our Cabinet of Mediation opened 1 month ago, so we do not have much things to share with you so far. In the meantime, we launched internal professional outreach. We informed all judges about a novelty and explained what was the purpose of having the mediation cabinet. The perception was mostly positive. Second, we undertook to share information about the mediation cabinet outside, basically to communicate the mere existence of such a cabinet. Our key target group is lawyers. We've heard of other Odessa courts having mediation cabinets for a while. However, many lawyers are still unaware of the existence of mediation cabinets. They were very much surprised. I wouldn't say that there were any signs of protest or bad attitude. They were just interested. Hopefully, we will be able to enhance mediation in the future. Thank you, Andriy. I'm sure there will be results, good results in the future. Our today's event is mostly targeted on the judiciary. That is why the event is mostly attended by judges. In the same time, mediation on the basis of courts can be facilitated only provided there is tight cooperation between judges and mediators. We've heard many judges today sharing experience of mediation cabinets being established. Now it's time to give floor to the mediators community to hear their perspective. And the floor goes to Luisa Romanadze, president of the Ukrainian Academy of Mediation. Thank you, Svetlana. The mediation cabinets are a brilliant idea as well. However, the way towards the opening of such cabinets was extremely long. Please share the presentation. I will start with saying a few words about the prerequisites for establishment of the above-mentioned cabinets. Trust underpins the establishment of the mediation cabinets. And my presentation is on. Next slide, please. We are awaiting for the next slide. Something went wrong. Some technicalities. I will continue talking while these technicalities are being addressed so that we do not waste time. So trust underpins successful functioning of mediation cabinets. That is why the core task was to establish trust. And the idea was to ensure trust not only in mediators, but also in the procedure of mediation. Since mediation is an unknown beast for many people, including from the professional community. And here we go with the presentation. The way of trust building was very long. The very first trust building event was held back in 2014. As you may see, we needed 4 years to make this way from the first step towards the opening of the first mediation cabinet. In order to build up trust, we had to ensure vast public outreach. We needed to explain to judges what the mediation consisted in, to highlight benefits of mediation for individuals, and how mediation may be beneficial for a better image of the judiciary in the eyes of citizens. Next slide. Next inscription, please. So we held outreach activities, seminars for judges. We held some practical events in many Ukrainian regions. The events were supported by the new justice program run by USAID. We set up several platforms for communication on mediation among judges. The platforms, smaller platforms, were established through the annual mediation forum, which usually takes place in summer. After having made primary outreach, we signed a memorandum of understanding between our academy and the judiciary. The document was not mandatory, as you can imagine. However, it said that the signing parties undertook to apply efforts to inform as many individuals as possible about the existence of mediation and its peculiarities. So nothing mandatory was put in place at that time. In the meantime, we were developing some information materials about mediation. It was our way to reach an even wider audience by way of presenting them information about mediation in a precise and concise manner. Then we focused on access to mediation in courts. We started by training judges and court employees on offering of mediation. In order to do so, we held seminars, developed roadmaps, and memory notes for judges. This year, we realized that training judges of pilot courts is not sufficient, and are currently thinking of expanding training on court employees, because the court employees are the ones who are contacted first by potential parties to proceedings once the latter come to court. We explained to both judges and court employees why it was fully safe to propose mediation with full respect of existing legislation. The second major step was the setup of mediation cabinets. After having established the first cabinet, we started informing people coming to courts about mediation and provide advice on mediation if needed. We also offer prior assessment of the dispute in order to make sure it is mediable, because even though mediation is an excellent tool for dispute resolution, it cannot be applied to any case. And finally, we ensured free of charge access to mediation at this stage. The third major step was setting up information support from court. It translated mostly into the placement of respective information materials at the entrance to court on the information desks, and making sure that court employees provide necessary basic information about the possibility of mediation. And the fourth major component was the development of information materials on mediation for various target audience. It's indeed very important to reach out various target audience, dispute parties to a dispute, lawyers, judges, court employees, since all of them have their role in the process and may either facilitate or impede mediation. On this slide, you can see samples of information materials. On the left, you can see booklets for judges, lawyers, and individuals, parties. And on the right, you could see the banner. This year, we've also developed a note on access to mediation. Basically, we are making a presentation of this note. The note was developed with the support of the Prava Justice Project. They helped us with the design and printing out. Next week, the notes will be spread out among courts. We've also designed and developed a booklet on the possibilities of reconciliation in court. So as you may see, the booklet is not specifically about mediation, but about various ways of dispute resolution in court. In the picture, you may see a stand with information about mediation. Some handouts are also booklets and brochures are also available there. On the right, you can see information about mediation, which is placed on the court's official website. In this pictures, you can see mediation cabinets. We are very proud of these cabinets. You may see that some cabinets are equipped in accordance with the best standards and remind of the cabinet demonstrated today by Judge Mario. You can also see here some statistics on the attendance of mediation cabinets in the pilot courts. So some 500 people attended the rooms, these cabinets, and some 40 mediations took place. Here I have to remind that mediation cabinets are available to all people, regardless of whether they are court clients, court users at a particular moment in time or not. The Ukrainian Academy of Mediation also provides room for mediation, and people can come and discuss their matters in a comfortable place.
And there is also an advantage that when mediation is held on the basis of the court next mediation, it is more trusted. That's what Larissa spoke about today. Next slide, please. It's there are a lot of examples of categories of cases where mediation office was addressed. It's commercial cases, it's cases related to family relations. So the list is not exhaustive. Maybe so far we don't have that many cases as we'd like to, as we could expect, given how much efforts are exercised to make it work. Nevertheless, in any case, it is a result. It is the success stories when mediation was able to help citizens cover their difficult issues. When we unexpectedly found ourselves in quarantine, we provided mediation online, and information about that was posted on respective official court websites. It's an example of how now mediation, you can see in the bottom, it's what Larissa spoke about, example of Kazakhstan. You cannot move further unless you read information that your dispute can be guided via mediation, can be settled via mediation. And the platform that was for online settlement of disputes, that was developed by a new justice. This year it was launched for to be used, and it has information that you can use mediation services. So next slide now, please. To sum up, we can say that there are some principles that have to be that have to be adjusted by court and mediators today that enable us getting a result. Next slide, please. Next slide. And we speak that it's free of charge. If we speak about cooperation with court, unfortunately, mediators can only say that it will be free of charge. In any case, given low awareness of mediation by the citizens, mediators do make this step, and it's a step to raise the level of awareness, of understanding how important it is. The same thing, this must be complex and systemic, it must be transparent, it must be without some interruptions. And what is important also to understand, when we started mediation offices, they were expected to function for 7 months, but then we continued mediation working, and then they have been in place for 3 years. It's very effective, and we only make a network of such courts bigger. And now you can see on the screen QR code where there are all the materials drafted by us that help us work and facilitate activities, and please use it. Please disseminate it and use it in any way you can. And we are doing it fine. And it's wonderful that we can use our contributions, and we are ready to support you, and we are ready to provide any logistical support for everyone. And we will be happy to provide access to mediation, to court next mediation. And I'm thankful to you for your attention. Thank you, Luisa, for your address, for your story, how it all started, and thanks to what it all was enabled. In course of this session, we have heard on how work is ongoing with 4 cabinets for mediation offices in Odessa. We hope that for all participants it was very interesting to hear Odessa experience of court-annexed mediation, and we do hope that it will give perspectives for rolling it out across Ukraine. Dear colleagues, you have a chance to ask questions to all the speakers of our panel. Please feel free to do that. But just first of all, say to who your question is addressed. If there are no questions, I finalize this session. I thank all the speakers for being with us, and it's my great pleasure to give the floor for moderation to the Justice of Grand Chamber of the Supreme Court, Tetiana Ansupova. Thank you. I hope you can hear me well. Good day. Welcome, dear colleagues, dear participants, and organizers of the conference. I welcome everyone who has joined us. Today, I see that we have 119 participants, and it seems more that it was at the beginning of the conference, and it shows that this is interesting for judiciary. Thank you very much for event, for invitation to moderate it, and this one will be devoted to court-annexed mediation in Ukraine, what prevents its development. And it is as a free discussion format, questions and answers. And today with us, we have in the panel discussion very experienced representatives of the judiciary. It's Larissa Shevtsova, member of the High Council of Justice, Justice of Kharkiv Appeal Court, mediator. Larissa is specialized in mediation and ADRs as of 2003. She has vast experience, and we have known her. I have seen her at some events held in the Supreme Court and the Supreme Administrative Court related to mediation. Also, today we have with us Inna Plachty, a judge of Lutsk Court of Volynsk region, member of the Council of Judges of Ukraine, participant of regional project Free Court Next Mediation. And next participant of our panel discussion is Ella Kataeva, judge of Odessa Circuit Administrative Court, that also is qualified as mediator and has been cooperating with the National School of Judges of Ukraine, drafts a number of curriculum on ADRs, and conciliation and settlement of dispute with participation of the judge, and has experience of holding 50 plus of such trainings on these topics. So I suppose we are almost sticking to our timing. We have about 45 minutes for that discussion. That's why I guess we will give floor for 10 minutes to our speakers and then leave some time for Q&As. And please, Larissa, the floor is yours. Good day, dear colleagues. It's a big pleasure, as usual, to participate in such an event because, in my opinion, mediation is one of the most relevant ADRs. And I want to say that, indeed, experience of other countries in using mediation shows that this tool can indeed facilitate some tasks. In my opinion, it's to give an opportunity to persons get access to justice. I already mentioned, and as already our moderator mentioned, in this session I participate in two capacities: as judge of appeal instance and as member of the High Council of Justice, because the High Council of Justice is involved in judicial career and disciplinary cases in respect of judges, and most of such complaints received in respect of judges have to do with the fact that parties don't agree with the decisions rendered, and about 90% of complaints have to do with consideration of appeal and cassation judgments. And if we speak about court annexed mediation as extrajudicial format, it will be a good opportunity to streamline the workflow for judges and to make sure that that parties don't get stuck in their conflict situation and that they can settle issues that there are in place. And as a judge of regional court from Odessa mentioned, the High Council of Justice, together with the State Judicial Administration, has prepared a report and has defined workflow per one judge that we have. Let's say whether it's exceeds the limits or that, in opinion of the State Judicial Administration, meets the rules established. And I can say that as of 1st January 2021, the State Judicial Administration defined the workload per judge. It's 76 cases per month for one judge. most judges in general jurisdiction, they have even more cases. As Mrs. Kirilenko said, some judges in Odessa region have a workload of 105 cases per month for one judge. And given this, we need to work on such dispute resolution methods as streamline the court's activities. We know that in 2016 there were amendments introduced to procedural codes, and there were opportunities defined to consider cases in so-called settlement of dispute with participation of a judge. But in my opinion, it didn't lead to any positive developments, given that in this case, the legislator put additional obligations on the judge that are not usual for the judiciary as to settling the dispute with participation of a judge, and that's why analyzing the register of court decisions, I can say that such procedures are very few and far between in Ukraine. And why? Because we know that in any procedure, we need to have an agreement on the part of both sides. And when a party comes to court, we understand that it tries to settle its issue only in court proceedings. When we enable the party to decide this conflict outside court, that is, to have recourse to mediation before submitting a claim and during consideration of the case and the stage of enforcement, then we give parties a chance to decide by themselves this conflict. And as to the fact that mediation procedure for now is very relevant, it's also corroborated by the fact that according to data, the statistical data, the judiciary as of 1st January 2021 lacks more than 2,000 judges. We know that the High Qualification Commission of Judges of Ukraine does not function, and because of that, there is no opportunity to appoint judges to respective courts, and that's why the workload per courts increases, and any procedure, especially procedure of mediation, in my opinion, will enable the parties to get access to justice and to settle conflict situations in a manner provided for by the law. Also, in my opinion, the most intrinsic method for us will be mediation. We know that mediation and arbitration have been used for a lot of time. First attempts to use mediation were introduced at the end of the 90s of the previous century. But as of now, the legislator does not set forth conditions for mediation, but we know that our mediators, our judges, even without legislative framework, do use these procedures and try to enable parties to settle the conflict on themselves. That is, when the parties come to the judge and try to understand all the circumstances in the case file that they have come with to court. So judges should explain to the parties what is the difference between procedure of settlement of the dispute with participation of a judge, how it differs from mediation. That mediation is enabling of parties. They own the procedure, they own the dispute. And in my opinion, consideration of draft law in the fact that the draft law was adopted in first reading, it enables us to come to a conclusion that indeed mediation in the nearest future will be set forth at the legislative level. I tried to tell it very quickly. Thank you. Thank you, Larissa. So then we have a chance to ask the opinion what prevents mediation in Ukraine. Now we will ask the next participant. It's Judge Inna Plachty. Please, the floor is yours. Thank you. Good day, dear colleagues. First of all, thank you very much to organizers and to Luisa Romanadze for invitation to participate. Odessa has always been very distinct and has always been very progressive in understanding that it's the biggest and most perspective thing, and progressive things have always been started in Odessa. I represent a small region. It's a Volyn region. It's far away from the center of Ukraine. At the same time, we are very close to Europe. We have a border with Europe that influences the mentality of people and judges as well. And I had a wonderful opportunity to participate in a project with the initiative of Civic Organization, Center of Free Legal Aid and Civic Organization. And in 2014, for Volyn judges to hold trainings relating mediation.
Судді віднеслися оптимістично до перспектив впровадження.
Judges were somehow skeptic in respect of court-annexed mediation. As judges, you can imagine that we are usually very skeptic towards novelties, and we want to keep and follow what's written in the books. However, some judges demonstrated motivation and have participated in that project. After the project, these judges started talking to their colleagues, continued cooperating with mediators, and over the 6 years, 6 mediations took place successfully. All of them initiated by judges. And more detailed information is available in the publication entitled Mediation in Courts, Myth or Reality. At some point in time, the USAID initiative joined the project which had been launched on the basis of our court. The USAID project contributed to the promotion of mediation. As to the discussion about obstacles on the way of court-annexed mediation, in my opinion, it's the lack of formal legalization of the status of the profession of mediation in the first place. The mediator needs to understand that he or she has a statutory defined status. It's important for self-confidence and for professional development. I personally am optimistic in this favor. I guess it will happen soon. Very close to our courts, there is a sort of business center, and one can see advertisement of notaries, of lawyers providing their services on that business center. Hopefully, very soon, the plate saying mediator will also be placed on that business center. I fully agree with the idea that judges need to apply efforts and promote mediation. So judges are in the position to inform about mediation and to offer mediation as a possible solution. However, the initiative is mostly on the shoulders of mediators. We used to have many mediators in Volyn region. They were mostly proactive and willing to cooperate with courts and judges. However, in the recent years, the number of mediators went down. Maybe they left, maybe they became less active and as a consequence less visible. However, all in all, I believe that mediators need to intensify their efforts and enhance their visibility. I truly believe mediation have perspectives in Ukraine, since people who are in favor and optimistic are quite numerous. Thank you. Thank you, Inna. Your ideas very much coincide with what I have on my mind. We will go back to your bullet points when we have a discussion at the end of the event. And now I'm pleased to give floor to Ella Kataeva, a judge who is participating online. Ella, can you hear us?
Да. Чую, дякую вам за гарне представлення.
Yes, I can hear you and I'm connected. Thank you for inviting me. I'll try to bring in some optimism to this a little bit more on discussion about obstacles to the mediation. So, mediation is a tool which is not very popular in our country, and the enhancement of mediation was a bit slowed down by the pandemics, as many other processes in public life. Back in 2020, we dedicated time that we could have dedicated to the development of alternative dispute resolution tools was dedicated to finding ways of ensuring access to justice in the traditional meaning of this word. So I'm talking about how to hold trials and how to adjudicate traditionally if there is no possibility to attend court premises. So you understand the problems that we were facing in 2020, and some movement in the area of ADR enhancement started at the beginning of 2021. What needs to be understood in the first place is that mediation is complementary to a trial, to a traditional way of dispute resolution. It's not something going apart or contradicting to trials. It's a complementary interest in. What is needed to have mediation properly implemented and applied? First, understanding and information about mediation. And I'm talking here about proper understanding. Second is the lack of a proper legislative framework. We've heard today of experience of European countries, of Georgia. I cannot but mention the example of Moldova. In Moldova, they went even further with the proper implementation of the mediation as a tool of dispute resolution, in the sense that the agreement reached in the framework of mediation is enforceable. They started implementing first amendments to mediation-related legislation back in 2007, and starting from 2015, mediation-based agreements are enforceable officially. Ukrainian mediation has a much longer history, even though unofficial. So the already gained experience need to be put in the basis of new law, new legislation. Larissa Zueva mentioned today that mediation needs to be available alongside judge-guided reconciliation in all jurisdictions at all stages, including administrative jurisdiction. Mindset and mentality need to be changed to achieve that purpose. This is true. But what is for sure not needed are additional efforts. Some people would say that mediation requires more time and efforts in comparison to traditional procedure, which is not true, of course. It's true that mediation requires additional skills and knowledge, but it's something which is fully achievable. Mediation for judges so also has its benefits for judges. Caseload for a judge in Ukraine is immense. That is why professional distortions and burnouts are occur quite often. And in this connection, at times judges cannot adjudicate the way they are expected to, fairly, in an unbiased manner, objectively. So this possibility to make a step aside and look at a case from a different angle may be refreshing for judges and may prevent them from professional distortion and burnout. In my opinion, it will also contribute to the improvement of public image of the judiciary, as well as public governance as a whole.
То не вистачало 30 днів, да? Тому що поки запросили, поки обговорили, поки
legislative amendments are needed not only in order to formalize the status of mediators and set up a clear procedure, but also to make mediation applicable in real life. The terms allowed for mediation need to be prolonged, in my opinion. For example, 30-day term for mediation in administrative disputes is not enough, because you can imagine that people who attend, representatives of administrative authorities who attend sessions are not usually decision makers. So they need to have their steps and decisions agreed with their hierarchy. It which requires time. That is why 30-day term should be prolonged. It's just an example of amendments which need to be implemented, in my opinion. The amendments, suggestions on amendments to existing procedural legislation in connection with the implementation of probation have been developed by a working group and submitted to the attention of the Parliament.
Сторони домовились під час врегулювання, неважливо, медіаційного, простого
In the
врегулювання
suggestions,
суді, не
we
були загально
also
доступними відомостями. Це спонукає і ще
mentioned that higher level of confidentiality to the agreement, mediation-based agreement, need to be attributed. So the conditions and terms of either reconciliation or mediation-based agreement need to remain confidential if parties do not decide in a different manner.
Щоб або медіація, або врегулювання спору за участю судді, це було по якимось певним категоріям і для цивілістів, і для адміністративних.
Reconciliation should be available
по певної якоїсь маленької категорії, але
as should be mandatory in certain cases, especially in civil and commercial jurisdictions. They might be just very little list of categories of cases, but some mandatory list need to be established, I guess.
Не проходили навчання і не дуже, я так думаю, обізнані з цією процедурою. І це теж осталось поза увагою.
People need to be trained to acquire mediation skills. Here I'm talking about young judges, but also about court employees. The lack of training on mediation leads to low trust in mediation, or at times to unawareness about mediation as such. It's true that international partners and some Ukrainian stakeholders apply much efforts to propagate mediation and other ADR solutions. However, so that their efforts are not in vain, we need to inform people even more. It should be really promoted in a strong and persistent way. And again, it's important to have the legislative framework adjusted. Thank you. Thank you, Ella. Dear colleagues, should you have any questions or comments to what the speaker said, please take the floor. We are awaiting for your answers, for your questions to be asked either in chat or orally. No questions so far. Let us continue then. Summing up what my colleagues said, there are three major problematic aspects which are obstacles to court-annexed mediation. First, understanding and perception of mediation, or better say lack of such understanding and perception. I believe it's of common understanding and of common sense that a judge who is willing to develop professionally and be open-minded cannot oppose to mediation. Mediation is a tool of the future. Second problematic aspect is communication. Many participants mentioned communication as a major problem. Again, lack of communication as a major problem. Everybody agreed that mediation needs to be promoted, and for example, the event we are holding today is a way to promote mediation. At this today, I paid attention to what Judge Bergman said. He said that not only judges, but also lawyers make efforts to promote mediation. He even gave us some statistics proving that lawyers promote mediation at the same level as judges. I believe it to be a very good idea. We really need to think of having lawyers on our side in terms of promotion of mediation. We may want to start with lawyers providing free legal aid. It's important to make sure that lawyers do not perceive mediators as competitors, but as colleagues who function in parallel with lawyers rather than replacing them. Another problematic issue outlined, the most problematic, I guess, Inna and Ella mentioned it today.
There are some challenges to legalize mediators' profession and finalize it in respect of legislative initiatives. I'm speaking now about the draft law adopted in the first reading, and another strand, I guess, is things that are possible without participation of the legislator. It's some practical aspects that we all can, as judges, put in place. It's dissemination of information by the way we have in 2018, 2019, but of course, pandemic made its respective amendments. But in 2018, 2019, our Cassation Administrative Court was very active, and the Ukrainian Academy of Mediation provided us with brochures that we disseminated among participants, among contestants, and we could see how interested they are as to this brochure text, and I guess nothing prevents it, and codes do not prevent the fact that judges can bring to the attention of the parties that there is a possibility to conciliate, whether they would like to have conciliation either with the engagement of a mediator or using Office of Court-Annexed Mediation or by themselves. But it's very important to remind that this opportunity exists and that court recognizes it as an alternative one and treats it seriously. In the same manner, in my opinion, all the opportunities with involvement of e-court as to mandatory consent or non-consent to have mediation before filling in a claim is it's all very important and relevant, and it's very interesting that we have definition of categories of cases that can be settled via mediation. And I want to draw your attention to the fact that we were interested before the quarantine and pandemic started, whether statistics was kept. Larissa Shitsova said that the procedure of conciliation with the participation of the judge didn't prove to be quite effective. And we even looked into administrative situation. As of 2018, there were no such statistics as to conciliation of a dispute with participation of a judge in administrative jurisdiction. So I guess these are some bullet points, some challenges that I'd like to emphasize. I thank everyone very much. If you have any questions, please feel free to ask. I see that there are some comments, questions to those of administrative justice. In 99%, representatives of authorities do not have the right to conciliate or recognize the claim. Moreover, most authorities, according to law, cannot cancel its decision. Only the higher body that is not a party to the case can cancel its decision. What's its decision? How can we conciliate such parties? And also there is one comment, I will read it out later. Are there any representatives of administrative jurisdiction that want to answer this question? I may answer it because it's about practical application. Yes, it is one of the problems that they don't have the powers to do that. But I think the only thing is willingness. If a state is willing to mediate, in one case, I had very interesting experience with all participants. It was a case on demolishing a building that was built without permissions in one of the resort areas, and it was even via appeals. The third person who did not, who wasn't engaged, it challenged in appeal procedure, and then saying that we need to apply these procedures in all instances, because later the agreement that was reached in first instance, the judge did this procedure in second instance, but without this procedure, and the third person refused to submit a claim. But to make sure that it all works finally, because participants were afraid to sign it, there were all steps against signing and agreement with line managers and with Kiev. So if there is willing, bodies can arrange it very nicely. When they didn't want to make some warfare, so they even had internal order regulation where at this session they said in this case it is necessary to enter into the agreement, and then it was a ground for issuing this order for conciliation, and then it was signed, and we had a very interesting case. Even it was commented on the Facebook. On the one hand, it shows that we have problems and we must be working with authorities to give them powers, to empower them. Now we're speaking about KPIs and about shifting the paradigm between the state and the citizens. But this example shows if there is willingness to enter into amicable agreement in any way, be it mediation or the settlement of dispute with participation of a judge, is possible. And we see the evidence that it indeed is possible. Thank you, Ella, for your answer. Indeed, we have participant, Mykola Zakurin, who insists that, for example, in tax authority, there is an order on challenging decisions that are adopted not in their favor. That's why first we need to work with the state. Maybe in administrative justice, indeed, there is such negative tradition to challenge everything up until the last instance, using not using the practice to conciliate. Unfortunately, it is in place and we need to be working on it in this area. Dear colleagues, are there any other questions or comments to participants of the panel discussion, quote annexed mediation in Ukraine, what precludes its development? There is a comment on the part of speakers from the other panel. May I? Yes, sure. I wanted to say that cases what my colleague was speaking, it landed in our appeal court, and there was third person who didn't sign the agreement, but it challenged it in appeal, and the appeal court couldn't but open the procedure. And it was very interesting how this case was considered in session court. In session of the court, the judge asked questions about how are the interests violated by conclusion of this agreement. It was some municipality who challenged this decision. Issues were based on mediation techniques, whether it violates, how will they have violation in the future, how it influences you, why is it so important for you. And in few court sessions, listening to such correct preparation of the judge to find out the circumstances of the case, the third party revoked the challenged, and the decision of the first instance was upheld because it wasn't challenged in the end. And when we hear that judges don't need mediation and let mediators live in their own planet and do mediation there, no, it's not right. Because when a judge asks questions in a way that the dispute should be settled, be it conciliation or mediation or just court session, when when parties are given the floor, not where there are claims, but where are the interests, why does the person give these claims? It's a skill that should be formed, and it cannot be done in a fortnight. It can't be done in one training. That should be done all the time. We should have mediation moods because the procedure is confidential. It's very difficult and almost impossible to land in the middle of a mediation center. That's why we have such collaborations with mediation centers and with other institutions. Some international trainings are in place, and we'd very much like to hope in this regard that judges would like to be engaged in a self-study, because training that is done once per 5 years, it's impossible. Each of us has this need, and I'd like to address you as moderator of this session. I know that you believe that conciliation, in particular, why conciliation is possible at appeal and cassation stage. I'd like you to support me and tell me, all the judges, not to be afraid to use this procedure, because no one prohibits it to us, and there is no challenge to the High Council of Justice that a judge did something wrong in mediation. So I'd like to hear your support as of the justice of the higher instance. Thank you, Larissa. You have my support. I think that we need to be based on feasibility and aim of justice, and we have to understand that we play the leading role in developing dispute resolution culture and conciliation with participation of a judge. It's a chance to come closer to ADRs, although in fact it's not an ADR, but in general, not to use this opportunity when it is in place, it would be strange, it would be not reasonable, and it would preclude the development of our country. And I guess all judges can be divided into those who are formalistic and those who want to be active judges. And I'm calling all judges to be active within professional ethics and within legislative framework, but to allow such possibilities for development, for developing culture of dispute resolution. Dear colleagues, if there are no further questions to our participants of this discussion. Maybe I can give the floor back to organizers to sum up the conference. Given it's high time to do that now, according to our agenda. Dear Luisa. Thank you, Tatiana. Thank you very much for your comment and for your wonderful moderation and how you structured this information according to strengths, according to highlighted issues that we know we need to settle that are there in front of us. In fact, what we named, why we named session in this way, it's about the fact that if we admit that there is a problem, it's 50% probability that it can be settled because there is this problem now. There is lack of trust. There are some impediments on the way to make sure that mediation works and that it does as effectively as possible if we have such joint work in other courts and with other mediators. I'm very much thankful to all participants, all of our sessions, everyone who has shared the experience. And we also thank interpreters who provided us with the opportunity to hear what colleagues from foreign jurisdictions said, their opinions and their lessons learned from this institute. And of course, we are very much thankful to EU Provo Justice Project that today this event took place, that it was that large scale, because indeed first we planned that it would be not as wide an event as it turned out to be, to share our experience, to show colleagues from our regions that mediation works, that mediation officers can be opened and mediation can be recoursed to, but thanks to project support, we were able to scale it up and to hear experience of foreign colleagues. And to finalize it, I will give the floor to Marina Mushkina, who will sum up today's event. All the participants, thank you so much. I will just say one thing. I guess I missed the discussion. I had to do some emergency work-related thing, but it's clear what we are speaking about. I want to pinpoint the fact that in commercial justice, court-annexed mediation, conciliation with participation of a judge, is facing the fact that judges should ensure the conciliation of the parties, but where is that verge? Where is that line beyond which courts cannot go? And moreover, in our cases, as a rule, we speak about big money and huge assets. And in these cases, we see that it's left out in courts. Courts don't see this. And in my 20-year experience of working as a judge allows me to tell the following truths. Nowadays, judges of commercial jurisdictions, I don't know how it happens in administrative jurisdiction, but commercial judges facilitated how? As maximum facilitation is if someone asks to suspend, to enter into conciliation agreement, then if it's not just with undue delaying of the case, if we see that it's real, we can do it. But other facilitation, all the time we are just under the burden of thoughts. I guess such agreement, someone has a right, maybe someone has an interest in this property, and combined with negative connotation, negative environment in general that is around courts, judges' activity on mediation currently, as questioners said, what precludes the development? The state precludes the development. That only now our top officials say that the main impediment on the way to development, it's the judiciary. Yesterday it was said by the president. Today it was said by the head of the Ukrainian security service, and this is aimed at a judge who is not afraid anything, who doesn't look around, and the judge that understands his value for society. But if it goes on like that, I don't know how it will be developing. Indeed, it is important for us to develop this because it enables for judges to be that much burdened with the caseload. But in the general, if that is the path of so-called development, it will be a huge a huge impediment, and we wouldn't be able to to have in place European experience. And that's why I think that the judges must pay attention to that, and we must have a consolidated answer to such threats. And I guess facilitation in mediations, to facilitation of the parties, maybe we will try to facilitate that trust is increased, but there is also the other side of that medal. And on numerous occasions, I hear such hints from participants of the process. Court is interested, and that's why the court says this. The court tries to make the other court to do that. So there is this problem. If we can speak about it, it will be just turning a blind eye on that, unfortunately. But the hope, as Lesa Ukrainka said, contra spero, I hope in spite of lack of hope. And we all hope that this time will come, and with full responsibility and with full freedom, we will be able to use court next mediation. Thank you very much. I just read news in the cabinet while I was looking up the resolution. I saw again the address of the president of the the security service of Ukraine that the judiciary is not effective. These are the messages, and I don't know how we can survive in these messages and how can we develop something in this. I just don't know who will be paying attention to that. So it's difficult because judges are trying not to get under some additional pressure.
Проблема є проблема, її треба озвучувати.
Does not sound very optimistic. However, it's something which is happening right now and right here, and we need to speak it out and look for solutions. Thank you. Thank you, Marina. Indeed, Ukrainian judiciary is in a very complicated situation right now, and even more respect towards judiciary is felt because judges make efforts in order to change things even when being under pressure. In this connection, I'm very grateful to all the proactive judges, to all the proactive adepts of mediation, and I wish all of you good luck.